Good morning. Welcome to all participants of our online marathon on training series about international and EU standards, labor standards, organized by EU-ILO Project towards safe, healthy and declared labor in Ukraine. This is our sixth, the last training on OSH related issues. It is a very comprehensive topic, and of course, we are going to make use of the protective equipment in order to protect our main organ, which is brain, which we need today and in the future. So today we are at the finish line, and I'm so happy that so many people have joined us. Let me remind you again that at the end of the marathon, you are going to pass the test. We suggest that you undertake it and you will answer questions for each of the modules. And if you are successful there, you will receive certificates for all the trainings if you pass all, or those where you successfully pass. And now let me quickly share my screen with the agenda so that we could navigate the time. So the main presentation by Antonia Santos is going to take place until 12. Then we will navigate our website where we keep uploading new information materials. Traditionally, we have cases, very interesting cases that will once again reiterate, or they will help us to clearly understand the practical application of international and European standards for OSH. We will take 15 minutes for Q&A, then we will summarize quickly, and we will switch to evaluation, and then we will have kind of festive wrap up of our online marathon, and we are planning to finish at 1:30. And I remember, based on the previous webinars, that one of participants quoted Lina Kostenka's words, "Every finish is a start." And that's true, because we don't finish there. We just open a new page of our further collaboration work for the next months, and Antonia will focus more on that. This is our agenda, and now Antonia would like to say a couple of welcome words to you. After that, we will hear Yuri Kusavoy from the Department for Decent Labor Department. And now, Antonia, the floor is yours.
Thank you for joining us again. This is the last training module, our summer marathon of all on trainings on international and European labor standards. This is about our safety, our health, and our life. That's why it's so important. So important. It's a pleasure to have you here again, and we hope that you like the training and also that you actively participate on it. This online summer marathon of trainings on international and EU labor standards comprised basically 6 modules. The first one was on an employment relationship. It was held in 25th of June. The second one was on part-time, and we included an additional module on telework, and that one was held on the 16th of July. The fifth module was held last week, and it was focused on labor inspection. This one, as already mentioned, is focused on occupational safety and health and the key international labor standards on occupational safety and health. The main objective of this summer marathon of online training is basically to improve the knowledge, the skills, and the capabilities of the national police decision makers, and also of the professionals that are engaged in drafting legal acts in this international and European labor standard. We expect that their increased knowledge about these standards may support a better alignment of the national legislation with those standards as foreseen on the EU-Ukraine Association Agreement. The conclusion of this online marathon of trainings is not the end. It's not. It's just the beginning. Our idea is that at the end of this online training series, the participants will develop the necessary skills, and we will have the necessary background and the necessary technical background to really help to change and reshape the national legislation in Ukraine. It is our hope that with the knowledge that was developed and acquired during these online trainings, the policy decision makers in Ukraine and the legal act drafting experts will be more able to improve national legislation. So the conclusion of these trainings is not the end, is the beginning. After the conclusion of these trainings, there is a huge challenge ahead, which is really to put it at work, to use the knowledge that was developed in order to improve working conditions in Ukraine. So let's start to reshape together the future of Ukraine. And in order to know a bit more about the Ukrainian government plans regarding labor relations, labor inspection, and occupational safety and health, we have here with us today Yuri Kuzovoy, which is the Director General of the Directorate on Decent Work Norms and Standards of the Minister of Development of Economy. So let's hear from him. Sofia, back to you. Thank you.
Thank you, Antonia. You've put and expressed it all, and the Department for Norms and Standards of Decent Labor. This is actually the department that covers all the issues that we've touched upon in the course of this marathon. So I have nothing to add, but to pass the floor to Mr. Yuri Kuzovoy. I'm happy to welcome you all, and I'm so happy. Well, I see that now we have 268 participants, and I believe that this is the golden pool of experts who are going to engage to further develop draft legislative provisions in the field of OSH, and you will engage in development of the main foundational law that we are now also focusing on in the ministry. I mean the law to implement Directive 391. And I absolutely agree that this marathon, that it is a very good basis, it is a very good background to get ready, to prepare, and to develop common opinion or common approach to vision and organization of safe labor and the OSH management system in Ukraine. I'm sure that we will need far not one more session or discussion to reach that goal. However, these workshops, they have already established significant basis, background for common understanding, for common approaches to develop the legislation. And I hope that today I will be present till the end because I have not visited all of your webinars, but I do believe that this topic is probably the most important one. And based on the outcomes of our work, we will be ready to soon present the draft law, respective draft law, to the public, and we will engage all experts, and we see that now there are even more of them who have joined us now, so we will engage you all to develop this draft law. So I wish you all inspiration. Thank you so much, Antonia and Sophia, for this titanic, huge job of raising awareness in the framework of this marathon, in the framework of the project in general. And I hope that due to our joint efforts, we will eventually complete the work that formally started more than a year ago in February 2019. And because of some organizational issues, reorganization at the ministry, it was slowed down a little bit. However, now, and to a great extent due to the fact that the project was extended, I believe that we will start finalizing preparation of or drafting the legal acts, including the framework law on implementation of Framework Directive 391. I wish you inspiration. You can have my contact information from Sophia, from Antonia. I'm always open to communication, and the ministry is very much focused on hearing as many opinions or ideas so that we could take all of that into account to ensure at the level of legislation achievement of the main objective, which is zero traumatism, zero lethality. Everybody needs to come home alive and healthy after work. So thank you all, and inspiration to you all again. Have a good day. Thank you, Yuri. And I really want to reiterate Yuri's statement that all of these activities are being implemented so not only so that we had a greater level of knowledge, but so that as many experts who deal with labor relations, with OSH issues, so that all of us were in the same ground, on the same ground of knowledge, information, awareness, and understanding. And thus, when we have the same framework of knowledge, when we engage into discussion, when we discuss some issues in the course of these trainings, we harmonize our standing, our position. And I'm sure that that will contribute a lot when we coordinate draft legislation so that we could arrive at consolidated versions of these documents. Now let's switch to the main part of our event. This was warm-up. And now I pass the floor to Antonia Santos. He will speak about OSH, and this is a very comprehensive topic. It is very difficult to fit that into 40 minutes of his presentation, and we try to do our best to present the information relating to this issue at the international level, EU level, at the national level, in such a way that you could see like a snapshot of all the elements that matter, that are critically important in this area. Antonia, the floor is yours.
Thank you, Sofia. Thank you, Yuri. I cannot stress too much the importance of the national legislation of Ukraine with international and European labor standards on OSH. It's really very, very important, both for the employers and for the workers, and also these online trainings, and in particular this one that we are conducting on occupational safety and health, should not be seen as an end in itself. It's not. It's a mean. It's a mean to an end. The end should be to improve working conditions in Ukraine, should be to ensure that every worker has safe and healthy working conditions. That is the end. This training is only a mean, is a way of providing the knowledge and the technical guidance and the documental support for the policy decision makers and for the legal acts drafting experts in order to help them to better align national legislation with this international and European labor standards on OSH. It's not an end in itself. It's just a contribution for that purpose. And of course, the ILO in general and our project in particular, we are more than happy to help. We are here to do so. So please, if you need our help, we will be grateful to contribute, and we will be very happy to help. And why? Why should we improve working conditions in Ukraine? Why should working conditions be improved anywhere in the world? Why is OSH so important? Well, we can see that on the slide number 3 of our presentation. Really, there is a paradox in dying working. And the paradox is clear. Why do we work? We work to ensure our subsistence, to have dignity, to reasons of personal fulfillment, self-esteem, social cohesion, etc. That's the reasons why we work. But paradoxically, we die working. There are persons that wake up in the morning, they have breakfast with their family, they kiss goodbye their families, they went to work, and they will not see them again because they die working. You will not come back to the house after a day's work. That is the paradox. And we should stop it. We should ensure that everybody that goes to work in the morning comes back safe in the end of the day. That's what should lead, what should guide the police decision makers and the legal act drafting experts. As ILO says, and that's another paradox, work kills more people than wars. And there is a figure that is put it forward by the ILO, which is that from around the workforce of around 2.8 billion people annually, around 400,000 people die in 207 million work-related accidents. And about 2 million people die due to occupational diseases. And that is really too much. In Ukraine, for example, the incidence rate of fatal work-related accidents is almost the triple of the average incidence rate of fatal work-related accidents in EU. So there are a huge space for improvement in Ukraine in what comes to reduce the incidence rates of work-related accidents. Work-related accidents and occupational diseases have devastating consequences for the victims of the work-related accidents and occupational diseases, as well as for their families, both at the human level and especially at the human level, and also at the financial level. But also they have a huge impact, negative impact on both the employers and the states at large. And these consequences in financial terms can reach up to 4% of the gross national product. Ukraine, as you can see on slide number 5, has some important challenges in what relates to occupational safety and health. Ukraine has a downstream approach to OSH, which is basically focused on protection rather than on preventing the occurrence of work-related accidents or occupational disease. Is that if work-related accidents and occupational diseases or the bad working conditions are a situation that we have to deal with. It's an inevitability. So Ukraine is more focused on repairing and on correcting than on preventing the occurrence of the work-related accident and occupational diseases from the outset. Moreover, it has an approach, a silo approach to occupational safety and health, in which you have a clear distinction between safety issues that you call labor protection and labor hygiene issues. And that's why you have different legislations on what you call labor protection, different legislations on what you understand to be labor hygiene, and also the organization of the State Labor Service of Ukraine also observes this silo-oriented approach in which you have labor inspectors which are specialized on labor protection and labor inspectors that are specialized on labor hygiene. But the truth is that occupational safety and health requires a more holistic approach, because you cannot separate issues from labor protection from the issues from labor hygiene. They should be seen as safety and health. And the same, and this idea of calling labor protection, calling safety labor protection, also gives us the idea that we are talking about protection and not about prevention. The most important approach that should be endorsed by Ukraine should be really to focus and to invest on prevention, not on protection. We should strive for preventing the damaging occurrences from happening from the outset, and not to correct it or to correct the consequences afterwards. It's more expensive and it's much more damaging. Moreover, in Ukraine, there is a too detailed, complex and outdated OSH legal framework with an excessive number of laws, some of which, and laws and regulations, some of which are contradictory between themselves. In addition, you have counterproductive legal provisions. For example, when you have legal provisions then foresee the payment of higher wages and the provision of additional benefits for workers that are engaged in heavy work or work with harmful or hazardous working conditions, you are giving a message. There are plenty of workers that prefer precisely to work on these hardship and hazardous working conditions than in workplaces that have good, safe safety and healthy working conditions because they earn more money. And that is a counterproductive legal provision. What the employer should be required to do is to improve working conditions and to ensure that the working conditions of the workers are safe and healthy, not to kind of compensate them because they are exposed to less healthy working conditions. And the same applies, for example, for the regulations in which it's foreseen that the employers are required to spend at least 0.5% of the wage fund of the previous year on OSH activities. And that is wrong because the obligations regarding OSH within the international labor standards and within the European Union acquis is an obligation of result, is not an obligation of means. The idea is that it doesn't matter how much you have to spend on OSH. What really matters is if you are able, if you really ensure that the working conditions that the workers have are safe and are healthy. There might be employers in which the working conditions are already good, and so they should not spend, they don't have the need to spend additional funds in improving the working conditions, in improving OSH. Whereas there might be others, employers, that the conditions are so bad that even spending 0.5% in OSH activities is not enough, is not even close. Moreover, if you set a threshold to an employer of spending 0.5% of the wage funds of the previous year on OSH, you will feel that once he spends that amount, he's okay. He already spent the amount, he already complied with the OSH regulations, so he does not have to do anything else, which is wrong. Again, it's an obligation of result. Workers have to have safe and healthy working conditions ensured by the employer. And that is an obligation of result, it's not an obligation of means. There are other obligations of means, but the most important one is this one. Moreover, the Ukrainian national statistics on occupational accidents and diseases are very unreliable. They present several inconsistencies, and there is a high level of underreporting of occupational accidents and diseases in Ukraine. And that is also related with the fact that Ukraine has a high level of undeclared work and informal economy, which also contributes to higher levels of underreporting. That is a very important challenge in Ukraine. National OSH legislation does not foresee the obligation of the non-transferable obligation of the employers for ensuring the safety and health of the workers in all aspects related to work, as foreseen on our slide number 6. In addition, national OSH legislation does not apply to all employers and to all workers. And as you can see on Article 4 of the directive, the EU OSH Framework Directive, member states are expected to ensure that all the employers and all the workers are under the scope of the provisions of that law, of that directive. It means that trainees, apprentices, interns, even self-employed workers, which should be considered on the economic dependency of the beneficiary of the activity, should also be covered by OSH legislation. And as for the employers, all the employers should be covered by this OSH legislation. In all sectors of activity, public or private, even if they are not companies, they might be other organizations of the third sector, they might be public organizations, public entities, including organizations from the informal economy. They should be also covered by the OSH legislation. Moreover, national OSH legislation also does not foresee the employer's obligation to take and continually adjust to changing circumstances the necessary measures to ensure the safety and health of the workers with strict observance of the sequential and hierarchical general principles of prevention, including the obligation to assess the risks and to implement the most appropriate preventive and protective measures that result from that risk assessment, to ensure the consultation and participation of the workers on the decisions regarding OSH. It doesn't also foresee the obligation of the employer to provide information, training, and the necessary organization and means to ensure OSH services at the workplace, and also the workers' health surveillance. Your labor protection law at the moment only foresees some of these obligations regarding specific types of workers, especially the ones that are engaged on hazards and harmful working conditions, instead of ensuring these services to all the workers. There is another important challenge in Ukraine, and that has to do with labor inspection. And why am I talking about labor inspection? Well, I'm talking about labor inspection because as it happens in any part of the world, it's not enough to have beautiful and very good laws on OSH, for example. It's not enough to have them perfectly aligned with the international labor standards and with OSH and with the European Union acquis. It's not enough, because if you don't have an effective system of labor inspection that promotes the compliance with the law, provides technical advices and informations to both workers and employers about the best way to comply with the legislation, that provides the improvement of the legal framework, and when necessary, that enforces the legal provisions and they ensure that they are really complied with at the workplaces, those beautiful laws will not be more than pieces of paper. So it is really important to have a system of labor inspection that ensures that the laws and regulations are really applied on the field, on the ground, on the workplaces. But the problem in Ukraine regarding the system of labor inspection is that labor inspectors lack the necessary powers to effectively discharge their duties. For example, labor inspectors in Ukraine cannot perform inspection visits at any time of day or night to any workplace without prior notice. They cannot perform inspection visits when the employer or his representative is not present. They cannot perform inspection visits without prior issuance of the respective order, emission of the correspondent certificate and register of the inspection visit on the information system, and of course prior notify the employer that they are going there. They also cannot widen the inspection visit scope beyond the authorization included on that documentation that is registered, and also they cannot widen the duration of an inspection visit even when the facts that they are seeing at the workplace and they could not foresee before justifies it. They also cannot make inspection visits with the duration, frequency, and deepness that they understand is necessary to ensure the compliance with the laws and regulations. Moreover, they cannot impose sanctions regarding infractions if the employer, once notified, corrects the infringement, and that is very serious, because all the employers will not have an incentive to comply with the legislation from the outset. They will be waiting for the labor inspectors to point out where are the infractions, because they know that they will have the time to correct them without being sanctioned. The dissuasive effect of labor inspection is lost. Moreover, labor inspectors cannot promote and enforce compliance of unregistered employers. And that is serious, because usually the unregistered employers, especially the ones on the informal economy and the ones that are engaged on undeclared work, are usually the ones that show the highest levels of non-compliance. And finally, labor inspectors in Ukraine cannot suspend works even in the event of serious and imminent danger to the health, safety, or life of the workers. Other problems with labor inspection in Ukraine that have a negative impact on OSH, and they include, for example, the recurrent imposition of moratoria to inspection visits. In particular, during the quarantine, for example, there is a ban or a moratoria on inspection visits, which does not make any sense, by the way, because during the quarantine, on the context of this coronavirus outbreak, is when the employers need more help and the workers need more help, guidance, technical advice, information in how they can prevent and protect workers from the contagions of coronavirus at the workplaces. This is precisely when they need more, when they need most the labor inspectors, they cannot provide their services. They cannot do inspection visits. And we should see this as a way of helping also the employers, because labor inspectors can provide technical advices and information to workers and employers on how best prevent and protect their health and their safety regarding the contagions of coronavirus, and at the same time, how they can ensure business continuity. Moreover, labor inspection system in Ukraine is also ineffective because SLS has a huge mandate which compromises the discharge of the labor inspection primary duties, and it prejudices the authority and the impartiality of labor inspectors. Moreover, the reasons of this lack of effectiveness of labor inspection system in Ukraine that has negative consequences on OSH can also be explained by the insufficient inception and continuous training of the labor inspectors, and due also to their inadequate working conditions and insufficient means to discharge their duties. So, and the importance of labor inspector, of having an effective labor inspection system is so important for OSH then that both the ILO Convention number 155 on OSH and the work environment foresees on its Article 9 that the legal provisions on OSH should be enforced by an effective system of labor inspection. And also Article 4 of Directive 89391 also foresees that member states should ensure the enforcement of the provisions of the directive through an effective system of labor inspection. As for the international labor standards on OSH, the legal framework of the OSH at the international level, basically you have four main international labor instruments on OSH. First, the promotional framework for occupational safety and health, which is the convention number 187, and that is a generic convention that strives for the structure and the architecture of a national system of OSH, a national policy of OSH, national programs of OSH, and it foresees the way in which the member states of the ILO should apply the generic conventions on OSH, the ILO conventions on OSH, and also on labor inspection system, on labor inspection, namely the convention number 81 and 129. Then you have the convention, ILO convention number 155, that is focused on developing at national level and also at the undertaking level the measures to ensure the safety and health working conditions to workers. Then you have a protocol number 155 of 2001 that complements this ILO Convention 155, and this protocol is focused regulating the obligation of the employers to record and notify the occurrence of occupational accidents and diseases. And then you have the ILO Convention, which is also a key convention in OSH, which is focused on the development at national level and at undertaking level of preventive and protective OSH services. It's called the Convention, the Occupational Health Services Convention. And then you have two different groups of OSH standards. A group of OSH standards that are focused on protecting the safety and health of workers against specific risks, And then you have the convention number 115 on radiation protection, occupational cancer protection, working environment, air pollution, noise and vibrations. You have another convention 170, which is focused on protecting workers from the exposition to chemical agents, and also one on asbestos, convention number 162. Then you have a set of conventions on OSH that are focused on particular branches of economic activity. We have convention number 120, which regards hygiene in commerce and offices. You have the dock work OSH convention number 152. Then you have also conventions regulating the OSH in sectors as construction, mines, and agriculture. And this is basically the architecture of the international labor standards on OSH. In addition, you have several ILO codes of practices on OSH, and also the ILO OSH 2001 guidelines on the occupational safety and health management systems. As for EU, you also have a framework which is added by the European Union Framework Directive, which is the Directive 89-391, beneath with flesh out several individual directives which are focused on specific, the exposition of workers to specific risks, for example, to explosive atmospheres, to electromagnetic fields, to noise, to mechanical vibrations, to biological agents, to artificial optical radiation, to ionizer radiation, etc. Then you have a set of directives that are focused on protecting the safety and health of specific workers, specific sectors of activity, for example, on board the fishing vessels, on temporary or mobile construction sites, on mineral extracting industries, or sharp injuries in the hospital and the healthcare sector. Then you have a set of directives that are specifically targeting the safety and health risks of specific types of workers, like younger workers, pregnant workers, workers that recently have given birth or are breastfeeding, and workers with fixed duration or temporary employment relationships. And then you have some transversal directives like the workplace directives, the machinery directives, work equipment directive, working time directive, safety and health science directive, the directive on the personal protective equipment, etc. Within this presentation, we will be focused on the key international standards on OSH. We will be focused on discussing the Occupational Safety and Health Convention, number 155, the protocol of 2002 to this Occupational Safety and Health Convention, the Occupational Health Services Convention, number 161, and also the Promotional Framework for Occupational Safety and Health Convention, which is the convention number 187. And of course, we will also discuss the Council Directive 89-391, which is the European Union Framework Directive on OSH. It is important to understand that this directive, this EU Framework Directive, it applies to all workers in all sectors of activity. The exception is when more stringent or specific provisions in individual directives apply. In this case, they have precedence over the OSH Framework Directive. It is also important to stress that Ukraine already ratified the ILO Convention number 155 and the Occupational Health Services Convention 161. As for the directive, EU Framework Directive, according to the Article 424 and the Annex XL to the EU-Ukraine Association Agreement, Ukraine undertook the commitment to align its national legislation with this Council Directive by August this year. So it is a pretty tough schedule to meet, but again, you can count on the ILO and on this project in particular to help you to achieve that. Moving forward and try to understand what are the implications of these international standards that we mentioned before on the development of a national framework that ensures the right of the workers to safe and healthy working conditions. It's important to understand that it's not just about transposing norms or transposing particularly legal provisions. We should aim at transposing the framework, the architecture of the legislation on OSH, either in the international labor standards adopted by the ILO and on the European Union legal framework. There is an architecture, a structure. You have, for example, on the ILO, you have Convention number 187, which is a promotional framework for OSH, that is added by this ILO Convention 187, which defines the need for the member states to develop a national policy on OSH, a national system on OSH, and actions at national level, and also at the undertaking level. And beneath this framework ILO Convention, you have the Occupational Safety and Health and Working Environment Convention, the Convention number 155, that specifies what are the main obligations of the member states and also of the employers and of the workers. And it is complemented by the Protocol 155 of 2002 that establishes the obligations of the employers regarding the recording and the notification of occupational accidents and diseases. And also you have another key ILO standard, which is the Convention number 161 on the need for the member states to develop a national policy of occupational health services, and also at the undertaking level, the obligations of the employers to ensure that the workers have access to OSH, to occupational health services. And in addition, you have a set of directives that are aimed at improving safety and health in particular sectors of activity, and on the other hand, you have a set of conventions that are aimed at protecting workers from consequences of the exposure to specific risks. And there is a parallel with the European Union OSH framework also, because on the European Union you have the mother directive, which is this Directive 89-391, and beneath this directive you have directives, transversal directives like workplaces directive, work equipment directives, etc. And then you have directives that are aimed at protecting the health and safety of the workers, of specific types of workers engaged in specific sectors of activity, and also of the exposition of workers to particular risks. So what really needs to be done is to transpose the architecture, the framework of OSH, and not just of specific provisions, or not just of a specific directive or international labor standard. But it's important to understand that this transposition should start by the mother directive and by the mother convention, because they are articulated. And of course, it's important to ensure that this transposition or this alignment is made with laws that have with legal acts that have really the power to ensure its applicability and at the same time its sustainability. They should not be transposed by a minister order. They should be transposed by a law of Verona Errada. So it is important to ensure, and it's a result of this international labor standard, that it should be established in Ukraine a national policy on OSH, and that national policy on OSH should foresee the workers' right to safety and health at work ensured by the employer, the prevention of occupational risks and of occupational accidents and diseases should be based on the risk assessment. This national policy should foresee the technical conditions for the design, manufacture, import, sale, assign, installation, etc., and processing of the material components of work. It should foresee the substances, agencies, or processes that should be forbidden, limited, or subject to authorization. It should ensure the definition of the workers' exposure limits to chemical, physical, or biological agents. It should foresee the development of the technical and scientific applied research on OSH. It should ensure the education, training, and information. It should be guided by the need to ensure the workers' health surveillance, the need to raise awareness regarding OSH in order to develop a preventive OSH culture, and it should be guided by the need to have an effective system of labor inspection. This national legislation on OSH should also foresee the creation of a coordinated and coherent infrastructure or network that ensures the development of this policy, and it should be composed by entities, public, private, or cooperative entities that are acting on areas such as regulation, licensing, certification, standardization, research, training, information, consultation and participation, technical services of prevention, health surveillance, and inspection. There should be seen also at national level the implementation of several activities in order to implement, to develop this national policy and to ensure the functioning of this national system. There should be actions in order to promote the training, information, and awareness raising on OSH, to include OSH subjects on the curricula of all levels of education and training. The competent authorities should approve technical specifications on OSH. National and international labor standards relevant to OSH should be taken into consideration when applying to the legislation. Licensing legislation should contain OSH specifications. That should be ensured that the available work equipment, tools, agents they observe the minimum OSH requirements, etc. There should be ensured also an effective labor inspection system and a system to record and notify and investigate occupational accidents and diseases. This for one side at the national level. At the undertaking level, this national legislation should ensure at the workplace level the rights of the workers to safety and health working conditions, and in particular, the employer's non-transferable obligation to ensure workers' safety and health in every aspect related to work with strict observance of the general principles of prevention. And that implies risk assessment, avoidance of risk, assessment of the risk and control of the risk through the most appropriate preventive and protective measures, the provision of preventive and protective OSH services to workers, the provision of information and training to workers, the consultation and participation of workers in decisions regarding their occupational safety and health, and the assurance at the undertaking level of the health surveillance of the workers. So as foreseen on the international and European labor standards, at the level of the undertaking, the main employer obligations are as shown here. First of all, avoidance of risk avoidance, then to assess the risks that cannot be avoided, then implement the preventive measures in order to control risk, implement the protective measures to control risks when the preventive measures are not enough to eliminate or reduce the risks until an acceptable level, and risk assess. So risk assessment should be a continuous task of the employer. And on the other hand, as you can see on the middle of this figure, employers are also required to provide preventive and protective OSH services to workers, to provide information and training, ensure their consultation and participation, make the necessary arrangement for emergencies, ensure the surveillance of the workers' health, and provide, of course, the needed collective and personal protective equipment. Importance, it is also relevant to mention that the employers should follow strictly the general principles of prevention, which are on the right part of this slide. And there is First of all, avoid the risks, then assess the risks that cannot be avoided, combat the risks at the source, adapt the work to the individual, adapt to technical progress, etc., etc., etc. As regards the risk assessment, the main obligations of the employers include to assess all the risks to the occupational safety and health of the workers, include on the choice of the work equipment, the chemical substances or the preparations to be used in the fitting out of the workplaces. It also includes, following this risk assessment, to implement the most appropriate preventive and protective measures to ensure the workers' safety and health. And these measures should be integrated in all activities of the undertaking at all levels. Moreover, and regarding risk assessment, employees should be required to be at the possession of an assessment of the risks to safety and health at the work, of the work. They also should take into consideration the workers' capabilities as regards health and safety when entrusting them tasks. Employees' obligations should include that when several undertakings share a workplace, the employers should cooperate and coordinate the prevention and protection against occupational risks and inform one another and their respective workers regarding these risks and the preventive and protective measures that should be implemented. And employers should also be required to decide on the preventive and protective measures that should be taken and, if necessary, what equipment should be necessary to be used. Moreover, employers should also be required to establish and ensure the functioning of preventive and protective OSH services at the workplaces. And in respect to that, they should, first of all, designate one or more workers to carry out these activities. And if for any reason they don't have internally the necessary competencies, they should enlist outside services to provide these preventive and protective OSH services to their workers. They also should ensure that the workers designated or the external services enlisted are able to deal with the organization of preventive and protective measures, taking into account the size of the undertaking, the risks to which the workers are exposed or might be exposed, and its distribution along the undertaking. And in particular, the workers designated must have the necessary capabilities and means to do so. The external services that are enlisted must have the necessary attitudes and the necessary personal and professional means, and they should be in sufficient number in order to ensure the effectiveness of these preventive and protective OSH services. Moreover, the enlisted services or persons must be informed by the employer about the risks and corresponding preventive and protective measures that are at the workplace, both in generical terms and regarding each workstation. And they should also inform these preventive and protective OSH services about the measures regarding first aid, firefighting, and evacuation of workers, and also for situations of serious and imminent danger. Employers should also ensure that these preventive and protective measure or services, if needed, are able to provide a series of services to the workers. And that includes, for example, the identification and assessment of the risks, the surveillance of the factors in working environment and working practices that are likely to affect workers' health. They should be able to provide advice on planning and organization of the work. They should participate in the development of programs to improve working practices and to test and evaluate the health aspects of new equipment. They should be able to provide advice on occupational health, safety and hygiene, and on ergonomics and individual and collective protective equipment. They should be able to ensure the surveillance of workers' health. They should be able to promote the adaptation of the work to the worker, contribute to measures of occupational rehabilitation, collaborate in the provision of information, training and education on OSH to workers, to organize first aid and emergency treatment, and to participate in the analysis of occupational accidents and diseases. As regarding the arrangements for first aid, firefighting, and evacuation of workers, and also for situations of serious and imminent danger, employers should be obliged to take the necessary measures, including arranging the necessary contacts with external services, designate the workers that are required to implement such measures, define the actions that should be taken in case of serious and imminent dangers, and provide workers with the information and the instructions that should be followed in case of these situations. Moreover, employers should also be required to inform workers who are or may be exposed to serious and imminent dangers of the risks involved and the steps that should be taken to protect themselves from this situation. As you can see on slide number 19, in what regards these arrangements for firefighting, first aid, evacuation of workers, and also situations of serious and imminent dangers, employers are also required to take action and give instruction to enable workers in the event of serious, imminent, or unavoidable danger to stop the work or immediately to leave the workplace and proceed to a place of safety. They should also refrain themselves from asking workers to resume work if the situation of serious and imminent danger is still there. And they should also ensure that the workers are able, in the event of a situation of serious and imminent danger to their own safety or the safety of other persons, and where the immediate superior responsible cannot be contacted, to able that these workers can take appropriate steps to avoid the consequences of such danger. As for occupational accidents and diseases, employers should be required to record and notify to the competent authorities within the time limits established by legislation, and also maintain these records during the time prescribed on the legislation regarding occupational accidents, occupational diseases, dangerous occurrences, commuting accidents, and suspected cases of occupational diseases. They should also be required to provide appropriate information to workers and their representatives concerning the record system, the recording system, and also the notified cases. Also, in the one in which regards occupational accidents and diseases, employers' obligations also include to ensure the appropriate maintenance of these records and their use for the establishment on the prevention of the occurrence of such events. Employers should also refrain themselves from instituting retaliatory or disciplinary measures against the workers that have reported these occupational accidents, diseases, dangerous occurrences, or committing accidents or suspect cases of occupational diseases. Moreover, employers should also ensure the confidentiality of the personal and medical data of the workers that they possess. Also, they should keep a list of occupational accidents resulting in a worker being unfit for work for more than 3 days. And they should also draw up to the responsible authorities, namely to labor inspection, reports on the occupational accidents suffered by their workers. As for the obligation of the employers to provide information to workers, this obligation includes providing information regarding the OSH risks and the preventive and protective measures and activities in respect of both the undertaking and in general, and regarding each type of workstation and job. And also, they should provide information regarding the measures that should be taken in case of what regards first aid, firefighting, and evacuation of workers, and also regarding situations of serious and imminent danger. They should also provide information to workers where several undertakings share a workplace. In this case, they should inform one another and their respective workers and the workers' representatives regarding occupational risks to which they are or may be exposed, the most appropriate preventive and protective measures that should be in place, and of any arrangements for first aid, firefighting, or evacuation of workers, and for situations of serious and imminent danger. And also, they should ensure that only workers who have received adequate instructions may get access to areas where there is serious or specific danger. Moreover, employers should ensure that workers with specific functions in protecting the safety and health of workers, or workers' representatives with specific responsibilities for the safety and health of other workers, should have access to the risk assessment and the corresponding preventive and protective measures, to the list and reports of occupational accidents and diseases, and to the information yielded by preventive and protective measures, inspection agencies and bodies responsible for safety and health. As for the employer's obligations regarding consultation and participation of the workers on the decisions that concern their OSH, that includes the need to consult the workers and or their representatives and allow them to take part in all the discussions concern safety and health, including allow them to make proposals and to have a balanced participation in such discussions. And it also includes the obligation of the employer to ensure that workers and workers' representatives with specific responsibilities for the safety and health of workers take part in a balanced way or are consulted in advance regarding any measures which may substantially affect safety and health, in the designation of workers to carry out activities related to the prevention and protection from occupational risks, and to implement measures concerning first aid, firefighting, and evacuations of workers. Also, consultations on which regards risk assessment, preventive and protective measures to be taken, list and reports on occupational accidents and diseases, where appropriate, being consulted and participate on the decisions regarding the enlistment of the external OSH service providers. They should also be consulted on the planning and organization of the workers' training on OSH, and also on the introduction of new technologies. As for the obligations of the employers concerning the workers' training, that each worker has to receive adequate safety and health training, in particular in the form of information and instructions specific to his workstation or job. And this training should be adapted and should take into account any changes of the risks. And it should be given at least on recruitment, in the event of a transfer or a change of job, and in the event of the introduction of the new equipment or a change of the equipment, and in the event of the introduction of a new technology. Moreover, employers should ensure that workers from outside the undertaking engaged in the work in his undertaking receive the appropriate instructions regarding OSH risks during their activities on his undertaking. And he should also ensure that the workers' representative with a specific role in protecting the safety and health of workers must have appropriate training. As for the obligations of the workers, of the employers regarding the workers' health surveillance, to ensure that workers receive health surveillance appropriate to the OSH risks to which they are or may be exposed to, and also that the workers receive this health surveillance at regular intervals if they so require. But of course, workers have also other rights besides these ones. So besides the employment relationship is a syllegmatic relationship in which the obligations of the employers are also workers' rights. And in this sense, the workers' rights, as foreseen on these international and European labor standards, include, besides the general right to safety and health at work provided by the employer, and the related rights that we have seen before, like information, training, consultation, health surveillance, etc., workers also have some additional rights that are foreseen on these international and European labor standards. And they include, for example, not to be involved in any financial costs related to OSH measures. They also include not to be placed at any disadvantage if they are designated to perform some activities regarding the preventive and protection against occupational risks. And they should also be allowed adequate time to perform these activities. They should also have the right not to be placed at any disadvantage if they are designated to implement the measures for first aid, firefighting, or evacuation of workers. Also, they should not be placed at any advantage and should be protected against harmful and unjustified consequences if, in case of serious or imminent dangers that cannot be avoided, they left the workstation or they left the dangerous area. In addition, Workers should not also be placed in any advantage if, to avoid the consequences of a serious or imminent danger to their own safety and health, or the safety and health of other persons, and when they cannot contact the immediate superior, they take the appropriate steps to end this danger in the light of the knowledge that they have and the available technical means. They should also have the right to ask employer to take the appropriate measures and to submit proposals to mitigate hazards and to remove sources of danger. In case of workers' representative with the specific responsibilities for the safety and health of workers. Workers should also be granted with adequate time off without loss of pay and provided with the necessary means in case they are workers' representatives with specific responsibilities for the safety and health of other workers. Also, they should have the right to appeal to the safety and health competent authority if they consider that the measures taken and the means employed by the employer are not adequate or are insufficient to ensure the workers' safety and health. They should also have the right to submit observations during the competent authority inspection visits. Workers should also have the right to OSH training, and this OSH training should be provided during working hours. Moreover, particularly sensitive risk groups of workers should be protected against the dangers which specifically affect them. But of course, besides their rights and the obligations of the employers, workers also have obligations. Workers also are requested to adopt some types of behaviors and practices regarding OSH. Workers are required, first of all, to take care as far as possible of their own safety and health and that of the others that can be affected by their actions or omissions. Moreover, they also are obliged to make correct use of the machinery, apparatus, tools, dangerous substances, transport equipment, etc., that it were put to their disposition by the employer. Also, they should make correct use of the personal protective equipment supplied to them, and after use, they should return it to its proper place. Moreover, they should refrain themselves from disconnecting, changing, or removing arbitrarily safety devices that are fitted to machinery, apparatus, tools, plant, or buildings, and they should use the devices correctly. The workers' obligation also include to inform immediately the employer and/or the workers with specific responsibilities for the safety and health of workers of any situation they consider that represents a serious and immediate danger to the safety and health, and also of any shortcoming that they identify in the protection arrangement. Workers are required to cooperate with the employment and/or with the workers with specific responsibilities for the safety and health of workers for as long as it might be necessary to carry out any tasks that are imposed by the competent authority in order to protect the safety and health of workers. And finally, they are also required to cooperate with the employer and with workers that have specific responsibilities for the safety and health of workers within their field of activity for as long as it might be necessary to enable employer to ensure that the working environment and working conditions pose no risks to the safety and health of workers. So, and that is pretty much about the main implications of the international and European labor standards on when it comes to regulate at national level and also at the undertaking level the right of the workers to have safety and healthy working conditions. These are kind of the sum up and the synthesis, the most important aspects that should be considered by the national policy decision makers and by the legal acts drafting experts when it comes to align national legislation with the framework of OSH that is foreseen on international labor standards and also on the European Union acquis. These are the main aspects that should be considered when it comes to really draft the legal acts that will transpose this framework to the national legislation in Ukraine. So thank you very much for your attention. I will give back the floor to Sofia Letven in order for her to show you where you can get access to some additional resources on this, and then we will proceed with our training session. Thank you. Over to you, Sofia.
Thank you, Antonia. And let us switch to this advertising for us to have some rest. And Antonia, we are 20 minutes lagging behind. So let's think about what we're going to do, because we need to be on time at the finish line. Otherwise, we are not winners. So I see that here we have several people who are new to our webinar. So I believe that it is important to present information about where we have all the materials that we prepared for each of the trainings. Today you will receive this presentation with the website of our project. For this module, we are still completing the infographics. The training material, it is something that we are also going to complete soon, and we will update all the materials on OSH till the end of next week. So it is something that you can use already. And now I'm going to share another screen to show you the web page. So it is very rich in information. So let me emphasize these sections. Here on the right, you can see components section, and all the trainings 1, 2, 4, all of them are in labor relations and undeclared labor section. You click there and you move on to international online trainings on international and European standards, and there you see all the topics. This is labor relations, part-time job, etc. All of these materials as a batch are placed here. Why we decided to do it this way? Because actually this resource, it is like one-stop shop. You enter and you have access to all the information that is required by experts who develop draft legislation to have a better knowledge on certain issues. We have the international and European standards, the commented version, and infographics. Very briefly, the key aspects are described there. If we go to labor inspection, in this section, you will see all the materials for the training on labor inspection. And there you can see all the standards, interesting material, analysis of legislative framework in the light of international standards of 2008, but it is still relevant, and you have all of this information available. And in the section of OSH, you already have part of the materials presented today. These are the conventions. Now, this is first the working time and then OSH. Again, conventions, directives, unofficial translation mostly into Ukrainian. So I recommend you to be, first of all, guided by the original training materials. Infographics and presentations will be uploaded soon. So this is briefly information about our website. Do visit it. And next week, or maybe early after 2 weeks, we will send you the information message where you will have links to the materials. Now, Antonia, we need to switch to the cases.
Thank you, Sofia. Thank you so much. Well, we are 14 minutes behind schedule, so I will try to speed up the process. So I'm just sharing some picture that I took personally when since I came to Ukraine. I'm a labor inspector in Portugal. I'm not a labor inspector in Ukraine, so I don't have the access to the interior of the workplaces. But this was the first thing that I saw when I got out of the plane the first time I arrived in Ukraine. This is in Boryspil Airport. So as you can see, you see workers with the work equipment on near the edge of a building without any collective protections against falling from ice. This was in September 2017. The next slide, the slide 35, is a worker that is smoking on the entrance of a sewage box in the sidewalk in Hrečatek. This inspired one of our cases that we will discuss today. And as you can see on the right, you have a worker in a scaffold also in Maidan. this was one month later. This was in November. This is a worker carrying a mechanical ladder in a commercial center in Milan. The other one is a worker working in a rooftop. This building is near the Minister of Foreign Affairs, is the building where the judges are trained here in Ukraine, is nearby the State Labor Service of Ukraine. This was more recent in May 2020 in a commercial center. The guys these workers are working in a scaffold that are not properly mounted and that expose them to the risk of falling from high. This is in a construction site, also in May this year. As you can see, this is a 10-story building, and they are working on top of it without any collective protection or personal protective equipment against falling from heights. So as you can see, they are lifting a box full of beton in a platform. The box is not fixed, is not properly fixed on the platform. They are lifting it so it can fall down easily. They are raising it on top of workers, which is another huge infraction to the safety and healthy rules on construction. They are raising it over the workers. And as you can see, the workers are working in the rooftop, fixing bricks without any collective or personal protective equipment to prevent them from falling from heights. So these are situations that you can face in your daily life every day, everywhere. And that is very, very, very sad, because people die. People die with these situations. So thank you so much. Let's move on. Let's move to the case number one. So as you can see on the case number one is the case of, well, it is, by the way, a recent case that three days ago of 4 employees of the utility company Kharkiv Voda Canal that died on the 27th of July, 3 days ago. These 4 employees died during the repair work due to ammonia poisoning. In the news that was publicized, according to the news, they were working without personal protective equipment. Well, my question to you regarding this case, and probably you are aware of it because it was publicized in the news. Probably there are even colleagues from the State Labor Service of Kharkiv area that are dealing with the inquiry of this occupational accident. But my question would be, and my idea is to have the opportunity to discuss the international labor standards, apply this knowledge about the international labor standards that we are being sharing to this particular case. And in order to do so, I ask your actively participation. We want to hear from you. What is your opinion? And basically regarding considering the international labor standards, the international and EU labor standards that we present before, what do you think about this case? In your opinion, what in your opinion might have caused this accident? Should the cause be considered as suggested by the news, the lack of personal protective equipment? So this is basically the question that I addressed to you. Is it possible, as suggested by the news, that the cause of this work-related accident caused the death of 4 workers is the fact that they did not use personal protective equipment? So over to you, Sofia.
Colleagues, now I see several comments in the context of the photos and the video that the construction sector is one of the most hazardous or risky sectors there, because a lot of workers work under civil agreements or informally, and also if these workers are self-employed, then they undertake their own risks that are associated with implementation of various types of jobs. Now, speaking about the case one. Alexander Tishenko believes that the cause of that incident was that the workers were allowed to work without PPEs. Then there is no control. They speak about lack of control and the shift system. I don't know what you mean by shift system, but anyway, then there is no order to use PPEs. This is violation. They were not supposed to work without PPEs. On the other hand, it is possible that it was unpredictable that there will be emission of ammonium. Speaking about PPEs, many people mention PPEs, Alexander Tishenko, Irina Kornichuk. What is the order-based system or shift system? Can you explain? Because we need to translate that as well. Artem says that it is about lack of awareness of workers and flow of the employer and lack of ventilation at the working place. Then whether those employees or workers were provided with PPEs, was it their fault that they were not using that? Well, it's obvious that the problem is about PPEs, but the main problem, the core, is indifference. But I would say that now we need to speak about something more specific, not so much about indifference, but let's speak about legislative provisions and regulations. So lack of responsibility of the employer, whether in the international standards there is liability of the employer for this kind of incidents, lack of control and over labor conditions, etc. So this is a summary of the comments that I see in the chat box. The employer didn't stick with the criteria or standards for organization of labor or conditions of labor. Olga says that the employer is never kept liable for this faulty organization. And Tetiana also says that for this kind of incidents, maximum liability is the sanction of 1,700 euros, which is about hryvnia, sorry, which is about 500 euros. Okay, Antonia, that's it more or less for the comments. Can you comment on the case and let's go on then?
Thank you, Sofia. So, of course, we do not know the causes of this work-related accident. We can only extrapolate because we are not conducting the inquiry of this of the occurrence of this work-related accident. But one thing I'm pretty confident that it was not the cause, which is the absence of personal protective equipment. Because really, if we look into the general principles of prevention, the use of personal protective equipment is one of the last protective measures that should be taken, and only if they are foreseen in the risk assessment, and only if the other preventive measures were not enough to eliminate or to reduce the risk to an acceptable level. Let me stress that according to the Article 6 of the Directive 89-391, there are some general principles of prevention that are enumerated there that should be followed sequentially and hierarchically by the employer in what it comes to assess the risk and implement the most adequate preventive and protective measures. And the use of PPEs is one of the last ones. And you should have that in your mind. That's why I have the helmet on me. The helmet should be used whenever the rest of the measures failed to eliminate or reduce the risks. We should not rely on a PPE to save our lives, because as the proper name reflects, is a protective measure, a protection measure, not a prevention measure. And what is the difference? For one side, we have preventive measures. Preventive measures are the ones that are focused on preventing the event from happening from the outset, which are the most effective ones. And then you have protective measures, which the nature is completely different. Protective measures do not prevent the event from happening. They only reduce the consequences of the event once it happens. So that's why preventive measures should be taken first, and should, as far as possible, to eliminate or reduce the risks. And we should only implement protective measures when the preventive ones are not enough to eliminate or reduce the risks to an acceptable level. So, and if we look into the general principles of prevention, the first one is obvious, is to avoid risks. If you avoid risks, you don't have to protect yourself or prevent yourself from nothing. And then you have, the second one is to assess the risks that you cannot avoid, just those ones. And for that ones, and then you have several other principles of prevention, such as combat the risks at the source, etc., etc., etc. But the main idea that I want to stress is that PPEs come at the final stage of the list. In Ukraine, this approach to protection rather than prevention is also reflect on that. The idea that an employer gives a PPE to a worker, and so his obligations in preventing and protecting the workers against occupational risk is done, is a mistake. The obligation of the employers to ensure safety and health working conditions is not just to give a PPE. No, that is the last one. First one, he has to assess the risks, to identify where they are, quantify them, and define the preventive and protective measures that should be applied in order to prevent and protect the workers against those risks. It's not just about to give a PPE. That is the logic of protection. The event happened, so let's try to reduce its consequences. No, it should be the obligation of the employer should be to prevent the risks to materialize themselves from the outset, not to protect once they happen. So, but getting back again to our case, is also important to stress that usually, and as labor inspector, I have done already, and unfortunately, a lot of inquiries of occupational accidents, and usually occupational accidents rarely are caused by just one cause. Usually there are several causes that contribute at different levels to the occurrence of a work-related accident, and not just one. Moreover, when we try to identify causes of work-related accident, we should start to think about the general principles of prevention, because usually the occupational accidents occur when the general principles of prevention are not observed. And of course, they can only be identified, as I already mentioned, on the context of an inquiry or an investigation of an occupational accident. But we are at this stage extrapolating, just discussing a case for a theoretical purpose. So without any relation to the case that really happened, we can extrapolate about potential causes of this accident. And if I was asked about it, I would say probably, for example, the absence of the assessment of the risks to which the workers were exposed inside the water pipes, for example. That can be a cause of the accident. Also, the lack of preventive and protective measures following that risk assessment. Also, it can have been caused by the absence of provisions regarding work in confined spaces. For example, checklists of measures that should be taken before the workers enter into the confined space, into the pipes, or some scheme of pre-authorization of entrance of the workers on those pipes, depending on the checking of the procedures and the equipment that they should bear with them when they enter. Also, it can be also caused or aggravated probably by the absence of a rescue or support team at the entrance of the confined space. It can also be caused by the non-prior measurement and continuous monitoring of the inner atmosphere, in particular the concentration of toxic and inflammable substances or lack of oxygen within the pipes. It can also be caused by the non-use of equipment of mechanical ventilation, as it was already pointed out by some participants, or by the non-use of communication devices in which use could facilitate the communication between the workers within the pipe and the rescue team on the entrance. It also could be caused by the non-use of proper equipment for respiratory protection. It could also be caused or aggravated by the absence or the lack of rescue equipment and devices. And it could also result from the lack of information or training provided to workers. Usually, more than one cause can generate work-related accident. Usually, it's not just generated by one cause. In addition, and in light of the international and European labor standards, it's also important to emphasize that the employer have the obligation to record, notify, and analyze occupational accidents. You also have to keep a list of the ones that generates an absence to work over 3 days and draw the reports on those. This is foreseen on Article 11 of ILO Convention 155, also on Articles 3 and 4 of the ILO Protocol of 2002 to the ILO Convention 155, and also is foreseen on Article 9 of Directive 893-391. Moreover, and according to Article 14 of the ILO Convention 81 and Article 19 of Convention 129, both on labor inspection should be notified of the occurrence of this occupational accident, and according to Article 19 of ILO Convention number 129, labor inspection should have the legal competencies to conduct the inquiry of this occupational accident. And well, that's basically what are my comments regarding this case. So, Sophia, I would propose to move to the other one. Next case is a situation with Dmitro. Dmitro is a labor inspector of the State Labor Service of Ukraine for over 10 years. When he was walking on Khrechatek this morning, headed to the office, he noted that the worker was smoking while entering alone into a street sidewalk sewer box, a confined space. So, as he saw it, he decided to intervene in order to prevent the exposure of the worker to a potential explosive atmosphere within the confined space. So he presented himself. Good morning, my name is Dmitro, I'm a labor inspector, and well, what you are doing is unsafe. And he asked him if he was informed about the risks to which he was exposed and to the preventive measures that should be applied to his work situation. And he responded no. He didn't know about the risks or the preventive and protective measures that should be applied. So Dmitro then asked his name, and he responded, I'm Anton, and Dmitro asked him the identification and the contacts of his employer, and Anton gave it to him. After that, Dmitro called the employer and questioned him about this situation, and the employer told him that Dmitro could not conduct the inspection visit because he was not prior notified about this, the inspection visit, and because Dmitro was not allowed to conduct the inspection visit. But while they were discussing, a sewage box exploded with a worker within, generating again a work-related accident. So regarding this case, and considering again the international and European labor standards on OSH and the data provided on this case, what do you think about the situation in which Dmitro finds himself into, and in particular regarding the worker's information regarding the risks to which he is exposed, and on the preventive and protective OSH measure that should be adopted? And what do you think about the powers of the labor inspectors regarding the performance of inspection visits without prior notice, and the performance of inspection visits without the presence of the employer or of his representative. Sophia, over to you.
Okay, Antonia. Well, actually, this case is a case that emphasizes importance and significance of labor inspection and of OSH standards. But speaking about the previous case, their participants also came up with some comments, and I see a very close link between labor inspection and OSH system. It is obvious that this topic is very relevant. It is very relevant for all of us. There are comments about that labor inspection needs to, above all, execute supervision, oversight, and independent oversight, expertise, and training. These are functions that should not be key to them, meaning in this way, the labor inspection will be more focused and less biased. So I don't know, Antonia, maybe you could comment on that or not. I sent you to private chat several comments in English that we received from YouTube. Maybe you could look through that. Also, many people mentioned that there is no training for employees, or it is done only formally, superficially, and that results in this kind of situations. What else I see specifically for this case? This is like, you know, radio signal. You launch it and then you hear the echo, and we have a little bit of delay regarding comments to the situation that we are discussing here. So there is a comment from Natalia Melnik. If an employee is not interested in protecting his or her health, no preventive measures or inspectors will help. Because the employee was smoking, that was his fault, but the employer, of course, is also to blame because there should be at least 3 employees on the spot, and they should have PPEs. Someone also mentioned that there should be at least 3 of them, one working in the pipe, another one controlling ventilation, and the third one for a case of emergency. And I remember that in the news when they spoke about that case in Kharkiv, and they say why all of them died, because all of them went into the pipe to save the one who fell into it. So it means that they didn't have an algorithm what to do in case of this situation. Then reference to national standards. Question from Igor. If it is possible to consider the idea of joint training of both employers and employees and workers about OSH. That seems to be it, and maybe now I switch it over to Antonia, and we need to speed up because we have 4 interesting questions for Q&A. I would like us to cover them because our participants look forward to your comments, and now the floor is yours.
Well, thank you, Sophia. So let's move on. Regarding this case in particular, let me remember you that the workers have the obligation, as far as possible, the first obligation of the workers is to take care of their own safety and the safety of the ones that can be affected by their acts or omissions. So in this case, the worker should not be smoking. But again, as far as it's possible, so he should be informed by the employer about the risks and the behaviors that he should assume when he's working. So the employer has to ensure that the employee knows that he cannot do it because there is the risk of explosion because of the concentration of the gas within the confined space. And so if being informed about it, the worker, notwithstanding the information, makes an unsafe act like this one, well, he should be disciplinary liable and of course liable for the consequences of the unsafe act. But before getting there, the employer has to first assess the risks, second, define the preventive and protective measures that are more appropriate to prevent the risks to which the workers are or might be exposed, including training and in the informing workers, and then, of course, in this situation, ask the worker if he had information and training, and if he knew that he could not smoke, well, that it is another story. But from this is to respond to the comment that Sophia provided us with. But first of all, and according to the international and European labor standards, the employer should have assessed the risks to which Anton was exposed to, and following that risk assessment, implement the preventive and protective measures that should be in place, according to Article 6 of Directive 89/391. In particular, there should be there should be an evaluation of the risks to which Anton was exposed and the identification of the preventive and protective measures that should be in place, some of which we already discussed on the previous case, like an instruction of work for that purpose, a rescue team prepared, the right equipment to ensure the prevention of the risks and the protection of the worker against them. There should be measurements of the concentration of gases within a confined space and the level of oxygen. There should be, depending on the concentration, other measures could be taken, including respiratory protection of the worker and autonomous respiratory devices, etc., etc., etc. Moreover, in the light of international and European labor standards, the employer should have informed Anton about those risks and about those measures that should be taken and provided with the appropriate training as foreseen on Article 19 of the ILO Convention 155 and also as foreseen on Article 6, 10 and 12 of the Directive 89/391. As for the employer's arguments transmitted to the Metro, according to which the Metro could not perform the inspection visit because he was not prior notified and because he and his representative were not at the workplace, as foreseen on Law 877, they are not in conformity with the Article 12.1 of ILO Convention 81, and they are not in conformity either with Article 16.1 of the ILO Convention 129. Both, by the way, both conventions ratified by Ukraine in 10 November 2004, and thus they are valid and they are part of the internal juridical order of Ukraine, as foreseen in Article 9 of the Constitution of Ukraine, and according to which the labor inspector should have the power to enter freely and without previous notice at any hour of day or night at any workplace liable for inspection. So, contrary to what the employer says, the labor inspector have all the right to make the inspection visit without any prior notice and besides without the presence of the employer or his representative. Moreover, this is not also in conformity with Article 4 of the Directive 89/391, which foresees that its provisions should be enforced by adequate controls and supervision. And moreover, it also is not in conformity with Article 9 of Convention 155, which was ratified by Ukraine in 4 January of 2012, and thus, again, part of the juridical order of Ukraine, according to which the enforcement of legal provisions should be secured by an adequate and appropriate system of inspection. And the fact that the Metro could not carry out his inspection visit as it would be the case if the international labor standards and the EU acquis was applied, if he could do it, probably the sewer would not explode and probably Anton would be alive today and probably the employer should not have to pay a pile of compensations, not only to Anton's family, but also to the city because of the destroying of the sewer system in at least in Karachatek. So the fact that there is in place an effective labor inspection system is good for the employers, but is good for the workers too. It's good for both. And in this case, labor inspection system is crucial to ensure that workers really enjoy safe and healthy working conditions. And now, Sophia, I would propose to move quickly to the case number 3 with 5 minutes, and then we will move to the Q&A session. So case 3 is about Oksana. Oksana is also a state labor service labor inspector for more than 10 years. She received a complaint from a trade union regarding a scaffold that was installed in a building and it was not properly installed, and the workers are exposed to the risk of falling from ice and die. She registered the inspection visit on the system along with the respective grounds, dates, hours. She got the authorization of the territorial unit head, and she pre-notified the employer about the conduction, the performance of this inspection visit. Well, when she reached the workplace, she asked the employer if he assessed the risks to it regarding the use of the scaffold, and if he had identified the most appropriate preventive and protective measures that should be in place in order to ensure the safety and health of the workers that are using that scaffold. And the employer said no, he didn't assess the risks, nor he identified the preventive and protective measures. Well, but when she was examining the scaffold, she noted that on the rooftop of the building to which the scaffold was fixed, there were two workers of the same employer repairing the roof without any collective and personal protective equipment, and they were really exposed to the risk of falling from the roof to the ground, 10 stories down. So, in face of that, he told the employer that the works on the roof should be immediately stopped because the workers were exposed to a serious and imminent risk to their life, their safety, and their health of falling from ice and die. But the employer just responded that she could not suspend works in progress, even in the event of serious and imminent danger to the safety and health of the life of the workers. And he also told Oksana that the work area of the building roof was not included on the scope of her inspection visit, and that in addition, he was not obliged to carry out any risk assessments. And meanwhile, when they were discussing this, a worker just fall out from the roof and hit the floor 10 meters from them and died. So, in face of this situation, and considering the international and European labor standards on OSH, what do you think about the situation in which Oksana finds herself into, and in particular, the fact that the employer did not assess the occupational risks to which the workers were exposed, the fact that the employer did not implement the OSH measures that should be applied following that risk assessment, and in particular, the employer's statement that Oksana did not have the powers to suspend works, even in the case of serious and imminent danger to the life, safety, and health of the workers, and she didn't have the powers to widen the scope of the inspection visit to include the rooftop. And also, what do you think about the statement of the employer that saying that he does not have the obligation to assess the risks to which the workers are exposed? So, Sofia, in order to gather the contributions of our participants, I would give the floor back to you. Thank you.
I would like to quote a comment which, Antonia, I believe is very profound and important, or it is open to discussion. It is from Alexander Sukharukov. Antonia, he says, if employee violates OSH requirements, if he loses job, only then it will be a motivation for him to comply with the requirements. So I have the question, what do international and European standards say about sanctioning or firing employees if they do not stick with the OSH requirements? And second statement from Mr. Sukharukov is that, sure, there should be the will of the employer to implement these provisions or requirements or standards. Should it be really the will of the employer, or maybe something more? And then should there be any sanctions for violation of OSH requirements? So the question is if sanctions, fines would be efficient to stimulate employers and employees to stick with OSH requirements, if fines are an effective method. That is it. I believe we need to discuss that. Then there was a comment about that in Ukraine. Now there is this perception that labor inspection is one of forms to put pressure on businesses. While now the government aims at supporting businesses, making it possible for them to develop. So where is that thin line between putting pressure on businesses and an effective labor inspection? And should labor inspection be perceived as one of forms to put pressure on businesses? Maybe that is the reason why the mandate of inspectors is so limited. And now let me check in the chat box. Irina Kornichuk comments the case that the inspector informed the employer about the risk. Then it is about impeding work of the inspector, because the inspector can indicate the risks. So in any case, the employer violates the legislation. Tatiana Harun knows framework directive by heart. She quotes that it is important to ensure OSH in the workplace and the methods to improve that. So there is the objective of saving lives, which cannot be dominated by economic or financial interest. A lot of other quotations from the framework directive. Mr. Sukharukov says that we discussed similar cases last time. And sure, the employer is supposed to conduct risk assessment and to apply all the due measures, and the employer will be responsible for death of the employee. Let me see, maybe we have missed something. Unfortunately, according to Alexander Tishenko, prohibition of work is only possible with a court order, meaning if the employer refuses to stop the work, then the inspector has no mandate to insist on that. Serhiy Cherepansky refers to Article 39 of the law on labor protection, but unfortunately it is blocked by other laws of Ukraine. Now I pass the floor to Antonia to very briefly summarize, because it is important to discuss some pressing questions during Q&A. So the floor is yours.
I suggest to address the questions that you raised about sanctioning of employees, the fines, if they are an important way of ensuring the compliance with the laws, and the way labor inspection is seen as putting pressure on businesses to the Q&A session. And for now, I would address specifically the case, if that is okay. So, starting with the case, well, of course, in the light of the international and the European labor standards, especially as foreseen in Article 6 of the Directive 89-391, the employer should be obliged to assess the risks to which the workers were exposed, and also to take and to implement the preventive and protective measures aimed at securing the safety and health of the workers while engaged in work. Moreover, the employer should have informed Anton about the risks to which he was exposed, and also about the measure that should be taken following that risk assessment, and to provide him adequate training. As for the statement of the employer, according to which Oksana could not widen the scope of her inspection visit to include the rooftop, where the two workers were exposed to the risk of falling from height, Oksana had the right to widen the scope of the inspection visit. In fact, according with Article 16 of ILO Convention 81 and Article 21 of ILO Convention number 129, and I remember that those conventions were both ratified by Ukraine, and they are both part of the international legislation, juridical sphere of Ukraine, as foreseen on Article 9 of Ukrainian Constitution. Workplaces shall be inspected as often and thoroughly as is necessary to ensure the effective application of the relevant legal provisions. So she could really widen the scope of her inspection visit. And by the way, the same applies as for the duration of the inspection visit and as for the frequency of inspection visits, because contrary to what is said on Law 877, according to ILO Conventions 81 and 129, the inspection visits, the workplaces should be inspected as often and as deepness as it might be necessary to ensure that the legal provisions are applied. And those conventions were ratified by Ukraine, so they are valid in Ukraine. And this law 877 that foresees differently should be really revised. Moreover, to finalize, as for the statement of the employer that Oksana could not suspend the works that were in progress on the roof, even in the event of serious and imminent dangers to the safety and health and life of the workers, she could do it if foreseen on national legislation, as provided in Article 13 of ILO Convention 81 and also on Article 18 of Convention 129. In these cases, labor inspectors, if it is foreseen on legislation, can immediately suspend works, as it happens, for example, in Portugal or in Spain. Labor inspectors, in a situation of serious and imminent danger for the life and health of the workers, the labor inspectors should immediately suspend workers. And of course, only on serious situations, which implies that along with the suspension of the works, usually labor inspectors impose a huge fine because it's a serious situation. And the employers can only resume work with a specific authorization of the labor inspectors, following a visit to check if the conditions of work are proper. So, and that's pretty much it regarding this case. So I would give the floor back to you, Sophia.
We have Q&A. So, colleagues, the ball is on our side, and I immediately switch to questions. So, Antonia, there are 4 important questions. I will go 2 and 2 because they are interconnected. First question from Valentina Vorobey. The Ukrainian legislation, as you mentioned, sets a lot of benefits for working in hazardous conditions, extra payment, extra pension, etc. If in EU there are any compensations for work in hazardous conditions, I believe it's important to comment on that, because it is something that we do have in our reality. Is we are used to that, and this is how we think, what we discuss, and we need to know what the philosophy is applied in EU countries. And second question from Larissa Melnik. Isn't it too archaic or outdated to request that work equipment meets minimal OSH requirements? Maybe it would be better to formulate it this way, that work equipment needs to meet criteria that would ensure safe and healthy labor conditions. I mean, what is those minimal requirements and why do we mention them? And if it is enough to comply with minimal requirements, maybe the bar should be set higher. So, Antonia, now these 2 questions and then 2 more follow.
Thank you so much for the question. As for the questions of Valentina regarding the extra payment, well, the problem here is that the stipulation of an extra payment for hazardous conditions is a stimulus to the workers to work on such workplaces, and that is a mistake. A different thing is to compensate workers for specific conditions like night work, for example. But that is different from exposing workers to hazard working conditions in which their life and their health is threatened. That working condition should not exist from the outset. It means that you should not pay a worker an additional salary because he is exposed to ammonia or to dangerous substances, because the employer doesn't want to create a better working environment. No. First, the work environment should be better, and then the work is there. The idea, I understand the idea of compensating, but we have to think about the impact of that policy on the decisions of both employers and workers, not just the idea of compensating. Because this approach of protecting, compensating, repairing, etc., is wrong. Ukraine should shift to a preventive approach in which the events are prevented from happening from the outset. So if there is a work environment that poses threats, that poses risks to the health and safety of the workers, that work environment, that workplace should be intervened in order to ensure that the workers that are exposed to those conditions will not have health or safety problems. That is the rule. Not compensating them for being exposed to those conditions. As for the archaic concept of minimum OSH requirement, is not an archaic concept. It's to point it out that those are the minimum OSH requirements. That does not mean that the employers cannot have higher requirements, but the law establishes those which are considered to be minimum. And by the way, they are very high, they are very difficult to match. So don't be mistaken by the idea that they are minimum, so they are easy to implement, because they aren't. And if they were easy to meet, Ukraine would already met them. And that is not the case, unfortunately. And other countries, by the way. So the idea of calling them minimum is just to stress that employers are more than welcome to have standards more higher and more stringent than the ones that the law establishes. And let's remember that the EU is composed by 28 countries, or 27 now. And to reach consensus between all the countries is difficult, because the OSH requirements imposes obligations to the states, to the employers, and to the workers. And agreements on the type of obligations are not easy to achieve. That's why this platform of requirements was the minimum one which was agreed upon them. It does not mean that they should be complied with by law, because they are on the law. Once they are transposed, those minimum requirements are the legal requirements that should be met by everybody. But that does not mean that other companies, other employers cannot be better, cannot do better than that. So, and as for the first questions that were put regarding sanctioning of employees. Well, first of all, when it comes to sanction employees, we have to be very careful about it, because we have to understand if the employees were duly informed and trained by the employers regarding their obligations. Because you cannot sanction an employee for making a mistake in terms of OSH if you didn't train him, if you didn't inform him what he should do. First, you have to inform him of what his behavior should be, what should be the way in which he should develop his functions. You should train him on that, and then you can demand him to assume those behaviors. And of course, the employer has the legal power as employer to have the legal disciplinary power to, in face of infringement by the employee regarding some safety rules that he knows about, that he was informed about and trained about, if he violates it consciously, well, the employer has the necessary disciplinary power to sanction the worker. As for the question if the fines are an effective way of enforcing the law, well, I would say the following. The measures that should be taken in order to ensure the compliance with the law depends a bit on the reasons why the law is not being complied, first of all, and the behavior of the agents that are not complying with the law. Because if an employer does not comply because he doesn't know the law, so let's try to inform him first about the law so that he can comply with it. And on this case, the best approach would not be, in my opinion, to fine or to sanction, but to provide information and technical advice to them. If the employer does not comply because he can't, he knows it, he knows the law, he knows what he has to do, but he can't because he doesn't have the enough time or he doesn't have the enough resources in terms of financial resources, human resources. In that case, the best approach would be information, technical advice, negotiating some timelines, some time frames that are reasonable for the employer in order to ensure that the employer comply, share best practices of other companies in the sector that have developed similar situations, etc. And of course, there are cases in which the employer knows the law, he is informed, he can do it, but he doesn't want to comply. Well, in that case, yes, sanction, fines, notifications to take measures, suspension awards, make all the sense. So it depends really on the evaluation that the labor inspector makes in a given situation, what is the best inspection procedure to apply, taking into account the circumstances of the practice of the infraction. And finally, putting pressure on the businesses versus effectiveness of labor inspection system. Well, that is a challenge in Ukraine. In fact, in Ukraine, labor inspection system is seen as putting pressure on businesses, and that is one of the reasons why is recurrent in Ukraine the imposition of moratorias to inspection visits, and is also because of this idea that labor inspection system poses pressure on the businesses, that labor inspectors are not entrusted with the powers they need to discharge their duties as they are foreseen on ILO Conventions 81 and 129 on labor inspection. And that is a huge mistake, because labor inspection system, an effective labor inspection businesses is good for the workers and is good for employers. It's good to ensure the safety and health of work, and is good to ensure business continuity. Over to you, Sophia, to check if there is other questions that needs to be answered from our participants.
We have 4 more questions, and that seems to be it. Maybe in the course of your responding to them, we will see more questions, but I'm afraid that we have no time for more. So 2 more questions, then you, and then 2 more. Question 1. Anatoly Viyevsky, what are now approaches of ILO and EU regarding alcohol and drugs in the light of OSH? I mean, definition of identification of intoxicated employees, that kind of thing. Second question, if bullying is considered as a hazardous incident. She mentions a case that took place and they discussed bullying. They started discussing bullying as an incident at work. So the floor is yours, and try to be brief, please, because we need to stick with time.
So, as for the questions of Anatoly, regarding the identification of intoxicated workers, well, this is not an easy question, and the answer is not easy on this context. But anyway, there are several restrictions to the possibility of the employers to measure the level of alcoholemia of a worker on his blood. And secondly, there is some concerns about the confidentiality of the data of those tests regarding the level of alcohol on the blood of the workers. And usually in Europe, these measurements are considered medical acts, and as such should be performed by people that are habilitated to do so, and not by anyone. Plus, it should be ensured the confidentiality of the data on the tests that are made. So it is not an easy subject, but there are some practices, some best practices that can be shared in some European countries regarding the procedures for monitoring the level of alcoholemia on work, especially when they are drivers of public collective transportation means, etc. As for bullying, well, as you can see on the ILO definition of occupational accidents, they also include acts of violence. You can see it on the ILO OSH 2001 guidelines on occupational safety and health management system. Acts of violence, if they occur within the workplace, they should be considered as occupational accident. So, Sophia, over to you.
Thank you, Antonia. And we still have two more questions. They seem to be so tasty, sweet and tasty. First, from Yuri about PPEs. Can an employer independently replace PPEs that they receive from employers based on instructions with better PPEs? So if it is possible for workers to make the decision that some other PPEs would be better, because now sometimes employers bring employees to liability because they use some other PPEs not as set in standards or requirements for OSH. And here, sure, there are a lot of implications. Who needs to provide PPEs, whether it is necessary to describe in detail in national provisions which brands of PPEs need to be applied, whether we need to describe that at the level of legislation, and maybe some other aspects to that. And the second question from Mr. Sukharukov, it is about what is due informing, who and based on which documents decides whether it is due or not. So the second question is, what do you mean by adequate informing, information of employers? So who and how decides that it is adequate? And then in addition to that question, there is criticism from other participants stating that in general requirements, there are very kind of general statements. You need specific documents, specific reference to some acts of legislation. I believe that's an interesting comment. Maybe it reflects that aspect that you mentioned about the national legislation, that it is too detailed and that it is too step by step, so to say. There's two questions, I guess, Antonia, and we will wrap up Q&A.
Thank you so much for the questions. Starting on Yuri's question regarding the PPEs. First of all, according to the international and European labor standards, the PPEs, especially European labor standards, the PPEs, because there is a specific directive on the minimum safety and health requirements on the use of PPEs, the PPEs should be used when they result from the risk assessment. Following the risk assessment, the identification of the risks to which the workers are exposed to, and the measures that should be implemented, the PPEs should result from that risk assessment and should be considered only if the risks to which the workers are exposed cannot be eliminated or reduced to an adequate level by other means. So the idea is that the PPEs are the last resort, and they should only be used if the risk cannot be either eliminated or reduced by other means. And when the risk assessment suggests that the PPE should be used, it has to result from them what are the most appropriate PPE that should be provided to the workers. And the characteristics of the PPEs should be selected on the basis of the risks that the workers are exposed, and also taking into consideration other PPEs that should be used simultaneously. And they should be chosen with this criteria, because depending on, for example, the substances, the chemical substances to which the workers are exposed, the masks that they should use can be different. The same happens to, for example, to the footwear. It depends to the risks. The workers to be subjected to a heavy weight coming down to their feet. It depends on what is the risk, and on the basis of the risk, the PPE should be selected in a tailor-made fashion. And of course, the decision regarding the preventive and protective measures that should be adopted is of the employer. The employer is the one that has to decide what is the PPE that is most suitable for that situation. And different workers in different situations probably will have different PPEs. And but it's important, the employer has the power to say and to decide what is the PPE that the employee should use. But it's important to note that that decision should be based on a proper risk assessment, and not just by the price of the PPE or by what PPE the employer thinks is more important or more cheap or whatever. No, the criteria should be objective. And also, once it's decided, the employee is obliged to comply with the orientations of the employer in matters of OSH. And if he doesn't, he can be sanctioned according to the law of Ukraine. The employer has the disciplinary power of the employee. If the employee disobeys or disrespects an orientation of the employer, well, he might suffer the consequences, obviously. But it's also important to understand that the employees should have the right, if they consider, and that is on the international labor standards and on the EU acquis, if the employees consider that the measures and the means that are implemented and provided by the employer to prevent and to protect them against occupational risks are not enough, are insufficient, or are inappropriate, they have the right to file the complaints to the competent authority on OSH in order to ensure that the employer is complying. And that the means that they are giving to the workers, for example, PPEs, are the adequate ones. So this is important also to take into consideration. As for the question of Sukaruka, well, first of all, we have to think about, we should not forget that a European Union directive is a command to a country. A directive imposes to a member state obligations of results. So it doesn't tell in general to a country what are the steps, all the steps that he has to do to achieve a result. No, the directive usually defines the result and gives flexibility to each member state according with the national circumstances in the national legal architecture. It gives the flexibility to achieve that result in the most efficient way. For example, it says that employers must provide preventive and protective OSH services within the undertaking. But it doesn't say how. It just says that he should do it. These OSH services should have enough people, should have enough number of people. The enlisted, if the employer doesn't have the resources internally and the competence internally to provide those services, he can enlist others, he can enlist external service providers. But note that he also says that the workers from within the undertaking or the external ones that are enlisted should have the appropriate knowledge, should have the appropriate means, etc. But it does not define what are those means. It means that when transposing this directive, each member state has the flexibility to decide what are the appropriate number or the sufficient number of workers to deal with the provision of preventive and protect OSH services to the workers. It should be 1 per 20 employees. It should be 1 for 15 employees. For each 15 employees, it should be 1 for each 10 employees, or depending on the sector of activity, other risks. So the directive gives flexibility to each government to decide what are the most suitable processes to achieve the result. For example, it allows to the countries to regulate on the external service, service providers of these OSH services to the undertaking. It doesn't say how it should be done. It says that they should have the appropriate means, the appropriate professionals. So each state should regulate in detail how to license the external OSH providers. What are the requirements that these external OSH services providers should have? Number of professionals that they have, equipments for measurements they should have, equipment in terms of premises, installation, equipment that they should have in order to provide those services to companies. So the problem is that in Ukraine, you legislate about everything until the last detail, and that can be counterproductive. You should leave some flexibility. You should legislate on the basis of principles, then on the basis of rules, but not in a so detailed area that no one understands what you are talking about, or even complicating the way that the employers or the workers can really exercise their rights foreseen on that law. And that's pretty much it. Over to you, Sophia.
Let us wrap up and summarize this topic, this event. So, Antonia, you have 2 minutes to summarize.
Okay, so first of all, as we have seen, die working is a paradox. We work in order to ensure our subsistence and to have a sense of realization and contribution to the society, etc. But work kills, and work kills more than war. So that is a paradox that we should address everywhere. Moreover, consequences of occupational accident and diseases are enormous for the victims, for their families, for the employers, and for the state. Ukraine faces some important challenges regarding OSH. We talk about some of them. The approximation of its occupational safety and health legal framework to international and European labor standards on OSH, as foreseen on the EU-Ukraine Association Agreement. That is a huge challenge. Such approximation should start by the transposition of the OSH Framework Directive, and then and also with the approximation to ILO Convention 187, and then with the other most important. Well, I would say that the real challenge is to align with the framework of the OSH as it is regulated on the international labor standards and also on EU acquis. It is important to ensure that the law that will transpose the OSH directive also takes account on the provisions of the ILO Convention 187, 161, and 155, and also on the protocol of 2002, in order to ensure that the obligations of employers and workers regarding OSH within the workplace are properly aligned and properly articulated with also the obligations of the state itself to ensure the existence of a national policy and a national system and national programs on OSH. That articulation and that alignment at all levels in terms of OSH is absolutely essential to ensure that really workers will have safe and health working conditions. In addition, it should be considered also the importance of that of the legal act that will transpose this architecture should be a law Verona Rada in order to ensure its sustainability and the needed power really to be enforced. Also, it's also important in order to promote, inform and enforce compliance with the legal provisions on OSH, that Ukraine aligns its national legislation on labor inspection with ILO Conventions 81 and 129, as also foreseen on EU-Ukraine Association Agreement. Well, as for these challenges, Ukraine can count on ILO, and in particular with this project. We are ready and more than happy to help on this approximation process. The higher responsibility, however, rests with the Ukrainian people, and in particular with the Ukrainian government, Ukrainian trade unions, and Ukrainian employers' organizations. From our side, we provided the trainings and the tools. Now it's time to join hands and to get to work and to apply what we have learned during the last 6 weeks and put it really into paper, trying really to improve the occupational safety and health legal framework in Ukraine. As you already heard, Minister of Economy is resuming the work that was started almost a year back. So let's work together. You can count on us. We are willing to help. And thank you so much for your attention and your enthusiasm. Sophie, over to you.
So when we proceed with kisses and saying thank you and goodbye, don't forget to mention tests, because people are asking about tests. Let me express my gratitude for all the questions that you have come up with during the 6 trainings, because you've made them kind of interesting and sweet and tasty, because that was not just the empty discussion. We touched upon very important aspects for Ukraine. Thank you, because this is about your knowledge, about your expertise, and about your interest. And pass over to Antonio Santos to express gratitude and for us to cross the final finish line. After that, we understand that we reach a new start.
Thank you, Sophia. So thank you again for your attention and very constructive and enthusiastic participation. We are very happy. Our challenge to you is, please send us a movie, a video in which 1 minute video in which you give us your feedback about this session of 6 trainings, and we will share on our project Facebook page the 3 best or most comprehensive feedback videos, online trainings that we provided, meaning employment relationship, employer's obligation to inform, working time, part-time, telework, labor inspection, and occupational safety and health. So we will prepare a test in order to evaluate your knowledge in each of these themes, and we will send you the links to this test where you can do the test. We will send it attention to the email addresses that you used upon when you registered, and we will then correct your answers, and we will evaluate your knowledge in each of these modules, and depending on the successful passage of the test in each module, we will issue the competent certificates only regarding the modules in which you passed. Moreover, all the materials of the training, of these 6 trainings on 7 items, on 7 themes, including background papers, PowerPoint presentations, infographics, applicable international labor standards and applicable EU directives will be accessible and can be downloaded from our project website right now. The only exceptions which are still missing and will be uploaded shortly are regarding OSH and telework. And in particular, background paper, infographic, and PowerPoint presentation on OSH in Ukrainian is not still there. Well, in Ukrainian it is, but the infographics and the background papers in Ukrainian are not still available on the site, but they will be put it there shortly. As for the English version of the infographic, it is not still in the website, but it will be there. For teleworking, is still missing the background paper and infographic in English and Ukrainian, but in the next week, during the next week, or the latest, early the week after, you will receive an email for your register email address again with the links to all these materials regarding all these training modules, and you can easily download them up. Moreover, I would like to point it out that the finish line, we reached the marathon 42.195 kilometers. We just crossed it, but again, it's not an end. It's a beginning. We crossed the phase, which is having the trainings and developing the knowledge about the international and European labor standards. It's a first phase. Now we are able to start another one. And the other phase, the next phase, will be precisely to put into work what we have learned on the last 3 weeks, and in particular in applying it to draft the legal acts that will transpose this international and European labor standard that we talked about, on working time, on employment obligations to inform, on labor inspection, on OSH, on part-time, on telework, etc. And we are here to help. So do count on us. We'll be happy to help you on that.